Sources of international law. What is meant by sources of international law? Sources of international law refers to where states, organizations, individuals, and courts can find principles of international law. One broadly accepted definition of sources of international law includes Article 38 of the ICJ Treaty. According to Article 38, there are four main sources of international law, which are treaty, customary international law, general principles of law, and judicial decisions. The other sources includes committee, unilateral pronouncements, binding oral agreement, soft law, jus cogens, and obligations erga omnes.
One of the main sources of law are treaties. Treaties are legal bargains as an agreement or outcome of negotiation between parties. Treaties can also be called as agreement, convention, or declaration. Actors decide on the rules and obligations of these agreements within the states. So, it is faster to be enforced and more respected due to the fact they meet their own rules. Treaties can either be bilateral or multilateral, and treaties are major instruments of cooperation between countries in international law. So we must focus that treaty is consent-based and we need approval through an accession or signature. Treaties are legally binding upon parties involved. So it means that those people who made rules and regulations and agreed on the treaty must be legally bound on it. Moving on into international customary law. What is customary law? Customary law is the law that originates from the practice of states and is the oldest and most original source of international law. There are two elements of customary law, which is first, state law, and second, opinio juris sive necessitatis. State practice is the rule of the states and what they practice in their country, and there's a lot of rules prohibited by the international law itself to the states. Opinio juris sive necessitatis is opinion as to law or necessity. Therefore, an established international custom may bind all states whether those states contributed to the formation of the custom or not.
Next, we will move to the general principles of law. While treaties and custom are the most important sources of international law, the others mentioned in Article 38 of the International Court of Justice Statute should not be ignored. General principles of law recognized by civilized nations and was considered as the third source of international law. General principles of law are basic rules where the content is very general and abstract. It is not written down and there's no precise list of such principles. The examples of general principles of law is good faith principle that the conduct shall be honest and fair, respect for human dignity, that protection of human rights as an important principle of humanitarian and human rights law. Principle of proportionality, which means a state's acts must be a rational and reasonable exercise of means towards achieving a permissible goal. There are two approaches that exist in terms of general principles of law. First approach provides that treaty law, customary international law, and general principles of law are all separate and out. Meanwhile, for the second approach, the general principle law was considered as a part of treaty law and customary international law. Other than general principles of law, judicial decision also was considered as a source of law too. Under Article 38 of International Court of Justice Statute, it stated that judicial decision a subsidiary means for the determination of the rules of law. Judicial decision is the determination of law by a court of competent jurisdiction on matters submitted to its judgment. The judge must determine the facts and decide which law, tradition, or precedent applies to the case. Judicial decisions become the subsidiary sources of international law, where the past decisions which created the law have been a guidance for judges to refer back in future cases. In theory, judicial decisions do not make law, but are declaratory of pre-existing law. They are law-identifying or material sources of law. Although the courts are, in principle, not obliged to follow previous decisions, in practice, they almost take previous decisions into account.
Next, we're going to move on to the teaching of most highly qualified publicists. Article 38 explains include as a subsidiary means for the determination of rule of law the teaching of most highly qualified publicists of the various nations. Historically, the influence of the academic writers on the development of international law have been marked. In the heyday of natural law was analyzed, juristic opinions that were crucial, while the role of state practice and court decision was less valued. Writers such as Gentili, Grotius, Pufendorf, Beekenschot, and Vettel were the supreme authorities of the 16th and 18th centuries and determined the scope, form, and the content of international law. After all former sources of Article 38 have been covered, we will also identify a few less explicit ones. These sources do not have the binding nature of opinion juries. Nonetheless, states are inclined to respect them. Comity consists mainly of courtesy that surround diplomatic intercourse. They are not legally binding, but rules of politeness, convincing, and goodwills may later become binding rules. Court may also rely upon comity as a reason for not accepting jurisdiction case. Now, moving on to soft law. Soft law refers to a resolution of declaration of intended policy by a body of state. Soft law is a frequently misunderstood phenomenon, although evidence of its importance as an element in the modern international lawmaking is abundant, most notably in the declaration or resolution adopted by states in the International Conference or in the United Nations General Assembly. And finally, jus cogens, a peremptory or absolute rule of general international law. There is no agreement on the criteria for identifying which principles of the general international law have a peremptory character. Everything depends on the particular nature of the subject matter. Perhaps the only general accepted example of jus cogens are the provision on the use of force, genocide, slavery, and torture.
So, we would like to conclude here that there are different sources of international law, such as treaties, customary international law, general principle of law, and more. In their actual application, however, these sources are closely interrelated. They often interact by supplementing and replacing each other. Often a rule created in one type of source later emerges in the form of another source. Thus, these typical sources of international law ought never to be viewed in isolation.